Hello and welcome. I am Lian Wan, and this is Rappler Talk. It was called as a farewell gift. On the eve of her retirement, International Criminal Court or ICC prosecutor Fatou Bensouda asked the pretrial chamber for authorization to investigate not only the killings under President Rodrigo Duterte's drug war, but also killings by the supposed Davao Death Squad from 2011 when the president was vice mayor and mayor of Davao City. But President Duterte said he will never cooperate with the ICC. What does that mean? And just how does the ICC work? For today, we have Param-Preet Singh, an international law expert and the Associate Director of the International Justice Program of the Human Rights Watch. Pam, thank you so much for being with us.
Thanks so much for having me, Liam.
All right, my first question is about the woman of the hour, Fatou Bensouda. She succeeded her former boss, Luis Moreno Ocampo. What has her reputation been in the last 9 years that she was chief prosecutor of the ICC?
Well, 9 years is a long time. Maybe I can focus on a couple of defining investigations that I think tell a story about the kind of prosecutor she was. She pushed ahead with investigations in Afghanistan and in Palestine, despite really intense political pressure not to do so. In Afghanistan, in part because the scope of the investigation included abuses committed by US nationals, and in Palestine because of Israelis' resistance. But the fact that she moved ahead with those investigations, again, despite pretty intense pressure, which included sanctions by the US under the Trump administration, I think says a lot about the independence, the spirit of independence and impartiality that she brought to her work as the prosecutor.
So these vile words from President Duterte, I mean, even after she opened the preliminary examination, he called her names and then threatened to deport her. So this is nothing compared to the pressure she's been under in the different investigations that she's opened.
I would say, rather than make a comparison, I would say that it's part and parcel of the job. And especially when it comes to holding officials who otherwise see themselves as outside of the reach of the law, holding them to account.
All right. So Prosecutor Bensouda left us with really strong words. She said Philippine officials planned and ordered the killings of the drug war, and there was a grand modus to target a specific segment of the population. When we read the report, it's a 57-page report, we can see that there were many citations to publicly available reports, not also by HRW. In our process here, that can be called hearsay, and that's the line of the palace right now. What is the difference with the preliminary examination of the ICC?
So thanks for that question. And I can see why that would be a common misconception. The preliminary examination phase, by its very nature, because it doesn't come with full investigative powers, it's restricted to publicly available information. And we're not talking about pinpointing specific individual accused, where I think the question that you're raising about possible hearsay would be relevant. Here, we're just talking about establishing the context and the factual basis to justify the court's intervention, because there have been crimes that have committed in the court's jurisdiction. In this case, it's the crime against humanity of murder, and that so that the ICC has jurisdiction over the crimes. And the request then is to actually move ahead with a full-blown investigation, and for that she needs the permission of the judges to do so.
So that can be called like a fact-finding mission.
Yeah, fact-finding, establishing the scope to see if the ICC could even act if it wanted to. And here it seems like, again, the preliminary sort of boxes have been ticked. And so now it's about going into whether or not the judges will allow her to move forward with a full investigation where she would be examining evidence, pursuing evidence, and leads to identify individual perpetrators.
Right. So when we read the report, we can also see that there were many redacted information. Could we assume that those are first-hand sources of the Office of the Prosecutor that they're keeping confidential at this stage?
So I think that you can assume that there are reasons for that information to be kept confidential, whether or not it relates to first-hand sources. I mean, only the prosecutor can answer that question. But yes, generally when applications like this are redacted, you can assume that the redacted information would somehow trigger security concerns for individuals or could compromise the investigation if made public.
One thing that was glaring also to me in the report was the discussion of the nexus that she established between the individual act and the attack. Could you explain that more to the non-lawyers who are listening now, and why is that important to establish that nexus?
Sure. So again, in the preliminary examination phase, she's looking at publicly available information to figure out if the ICC could even act. Here, she thinks that threshold has been met. But then the next step is to figure out, who's responsible. So the nexus is important because these crimes obviously did not take place in a vacuum. So it's about establishing individual responsibility for the commission of those crimes, because the ICC is a court that focuses on individual accountability. So then again, that's why the nexus question is important. Yes, crimes are committed, but who's responsible? That's the next step.
As far as the history or the track record of the ICC is concerned, is 3 years of preliminary examination short or long? And how long are we looking at before the pretrial chamber decides whether or not to grant authorization?
So in terms of the length of preliminary examinations, it really varies. It's really hard. I mean, Afghanistan, that preliminary examination was much longer than the one for the Philippines, whereas a preliminary examination for Myanmar was shorter. It really just depends, I think, on a number of factors. The office is juggling numerous priorities. I mean, it has a number of investigations open in other countries, and they have limited resources. So it's hard to say if it's long, short, or average. They take as long as they take. In terms of the timeline for the judges to come back to her with a decision, or to come back to the office of the prosecutor with a decision, generally it's around 3 months. It could be shorter, it could be longer. Again, coming back to Afghanistan, it was over 2 years. But that's very much an outlier. I think we can look for a decision one way or the other in the next few months.
And if indeed an investigation is opened, how long are we looking at before the prosecutor, if ever, decides to ask for a summon or an arrest warrant?
Well, then it becomes a question of, once the office of the prosecutor is granted full investigative powers, so full scope, full authority to fully investigate the situation and identify those responsible, then it's just an evidence game. How long will it take them, the office, to compile the evidence to, in essence, prove the cases, identify and effectively prove the cases against those it's identified? And you have to remember that in the Philippines, no surprise to you, the government is not going to cooperate. They're not going to make it easy on the ICC. And so the court has to be really creative in investigating from the outside. And that is certainly possible. It's been done in other situations. But it does add potentially to the timeline for when we can expect to see arrest warrants.
Right. So we have talked before with the lawyers of the witnesses and victims of the drug war, and they have said publicly they're willing to cooperate with the ICC. So is that something that we can see if ever an investigation is going to be held, like maybe over Zoom or in whatever digital form, that the OTP will talk to these people?
So I think the bigger question is not how they'll, I think it's encouraging that people have indicated that they'd be willing to cooperate and provide information. But the ICC, the Office of the Prosecutor, also has a duty of care to them to make sure that in taking them up on that offer, whether it's remotely or in person, that they're doing so in a way that wouldn't compromise them, either in the moment that the interview is being recorded or longer term. And that's even if victims and witnesses are willing to come forward, it may be that the risks are too great and the ICC can't actually pursue those lines of inquiry. So it really just depends on a number of factors.
So the spokesperson for President Duterte, Harry Roque, he knows his international law, and he's been citing Afghanistan time and time again because at the first instance, the PTC denied authorization to investigate Afghanistan because of the lack of cooperation. Do you think it could be signaling also from our palace to the pretrial chamber that just don't open an investigation because we will never cooperate?
I mean, the government can signal as much as it wants to, and that's, again, not new information or not a new tactic. I mean, I think I can appreciate why he would cite the Afghanistan pretrial chamber decision, but it was pretty definitively overruled at the appeals chamber in that, it took into account inappropriate considerations in deciding not to open it or not to allow the opening of investigation. So aside from that blip, for the most part, pretrial chambers have confirmed, because the threshold is pretty low. It's in essence to check to make sure the prosecutor has dotted the I's, crossed the T's, and to make sure that her request is in line with the terms of the statute. Provided that threshold is met, they will open an investigation in the Philippines.
So is it correct 6 out of 6 of the requests for authorization have been granted thus far by the chamber?
Well, by the court, because Afghanistan was initially denied, and it was the appeals chamber that allowed the gave permission to open the investigation.
So at this point, even though we know that the drug war was a policy of President Duterte, there is no respondent yet. It's still a Philippine situation.
Yes. Although in practical terms, given that these were governmental policies, I would assume or expect that the Philippine government is scrambling to think about how it will engage with this and how it will defend itself in the months and years to come, should an investigation be opened.
Does the ICC always have its eye on the head of state, or have there been cases where it's not the head of state, it's generals or it's lower ranking officials? Do they have interest in small fish?
So the ICC, provided crimes in its jurisdiction have been committed, it has jurisdiction over all of the fish. But in terms of who, those who it will focus on, honestly, it depends from situation to situation and the strategy for building up the cases. Because of course, you can't, it's really complicated to start right off the bat with the head of state without the sort of underlying little fish evidence that comes out in trials that could be, help you build up to, that eventual prosecution. So it really just depends on the strategy and the evidence that's available, how much it's available, what the strategy is for, potential arrest and cooperation. There are a lot of different factors, but yeah, just to reiterate, the ICC, there is sometimes merit in going after smaller fish first in order to build up to the big fish. Sometimes it makes the most sense to make the most impact with limited resources to only look at the big fish. It just depends.
Assuming that our government cooperate, is the investigation the level where the defense could be heard?
Absolutely. The hallmark of an effective justice process is a fair trial, and a fair trial requires a strong defense. So yes, 100%. The ICC does not hold trials in absentia, meaning that the accused, in order to be tried by the ICC, has to be present.
Assuming, for example, that an arrest warrant or an arrest order is made, could we assume that the person being arrested is the person who is going to be put on trial?
Yes. And generally, I think the practice at the Office of the Prosecutor has emerged that, when you're requesting an arrest warrant for an accused, it's because you have the evidence to prove that conviction in court down the road. So, it's signaling, the beginning of a much longer process. It's not conditional. It's conditional on obviously getting the accused in the Hague, but once they're ready to go, they're ready to go.
I want to go back to your point about how the ICC does not hold trial in absentia. Could you walk us through the process from investigation to the confirmation of charges? How does it move along?
Sure. So let's say an investigation is opened. The ICC OTP, the Office of the Prosecutor, gathers evidence, identifies potential accused, submits an application for an arrest warrant to the pretrial chamber, which is either accepted or denied. Once those arrest warrants are issued, then let's say that the person in question is handed over immediately. It doesn't really matter when they're handed over. Once they're handed over, then I think within a set period of time, they have to make an appearance before the court, and then there's a confirmation of charges hearing scheduled. And at that hearing, at every step, the threshold to prove the case is a little higher. the confirmation of charges hearing, you know, the pretrial chamber is really probing into the case that the prosecution has presented to determine whether or not there's sufficient evidence to move forward with a trial. And assuming that that threshold is met, then there will be a trial scheduled with the defense present. The defense is also present at the confirmation of charges hearing. And, you know, then it's a question of just following the trial as it unfolds and then awaiting a verdict.
I'm seeing that the enforcement of the arrest warrants depend on the cooperation of the state's parties, and as you said, if there's no person in court, a trial cannot proceed. What's the incentive of these people to turn over themselves to the court? I mean, why not just hide in their country that does not cooperate?
So, I mean, I think if you look at other situations before the ICC, indeed, that is a strategy for a long time for some suspects. But, you know, it's really hard to speculate as to what their motivations would be to turn themselves over, or for people who, you know, seem outside of not just the reach of the law, but like literally the reach of the law because no one can find them. You know, they do find themselves, you know, in the dock in The Hague. Here I'm thinking of Bosco Ntaganda, who was a notorious warlord in the Congo. Ratko Mladic, Radovan Karadzic before the Yugoslav tribunal, you know, it took years for them to be, you know, arrested and handed over, but it did happen. So, I mean, I think in the abstract, it can seem impossible, but I think that's also the role of, you know, journalists and civil society groups and governments to just keep asking questions and putting pressure on, you know, those who have the power to arrest and hand over suspects, to underline why justice is important and raise the political cost for non-compliance.
Before I go to the point of pressure, some people have observed the timing because this seeking of authorization comes while President Duterte is still in power. He's still very popular. Would there have been a value of just waiting until he steps out from office before this move was opened?
So the International Criminal Court, I mean, it's an impartial, independent court, and its mandate, you know, as part of executing that mandate, its guide is the evidence. And I think in this situation in the Philippines, I mean, President Duterte's statements time and again have proven a lot. There's a lot of evidence in the public domain. I mean, leaving aside what's in the private domain or what others may share, there's a lot of evidence in the public domain to suggest that President Duterte, you know, he's worn this like a badge of honor, the drug war. He's worn it like a badge of honor, and he's encouraged it. So, you know, to your question as to whether or not it would have been better to wait, I would say the other side is we can't wait because this person who's endorsing crimes against humanity is still in power. And this could potentially be a powerful message that that conduct is not acceptable and that there could be consequences for it.
Right. So on pressure, the pressure seems to be United Nations Human Rights Council, the statements of both Human Rights Watch and Amnesty International also put a spotlight on the United Nations Human Rights Council. Sorry. What practical, in practical terms, what could a stronger move from the UNHRC bring to reinforce an investigation potentially by the ICC?
That's a great question. So while I said that the ICC is a judicial body, it's motivated by the evidence, the Human Rights Council is a political body. And it also should be motivated by the evidence to raise political pressure on the Philippines, both to stop these murderous policies, but also to cooperate with the ICC and hold those responsible for their execution to account. The Human Rights Council up until now, so last fall during the session, you know, the High Commissioner for Human Rights issued a scathing report just detailing, you know, the consequence of the government's policies on civilians, which I would say was largely, not that it was ignored, but it certainly wasn't addressed with the gravity that it required and the seriousness that it required. And instead of launching its own independent investigation, you know, launched into a partnership with the Philippines government for technical cooperation, which feels absurd for a government that has consistently denied that these abuses are even taking place and has refused to cooperate with any kind of independent investigation. So I think the ICC investigation is an opportunity for governments to reset and to rethink their approach to the Philippines instead of taking the path of least resistance and just bowing to what the Philippines wants, the government of the Philippines wants. This is an opportunity for governments on the Human Rights Council to course correct and say, look, we're going to stand, like even the ICC has said that they think that this is crimes against humanity. We want to stand with victims and we want to put pressure on the Philippine government to address the situation. And in terms of how that would support the ICC investigation, I think it would really up the pressure to cooperate with the court. But also remember the ICC investigation, the Philippines effectively withdrew in March of 2019 from the ICC's jurisdiction. So the ICC can only look at crimes from 2011 to March 16th, 2019. So Human Rights Council investigation, in addition to upping the pressure, would also cover this gap because these crimes are continuing. And there's no way for the ICC to touch them. So all the more reason for the HRC to step in.
Because there's a technical cooperation with the UNHRC and the Philippine government, are we looking at maybe the ICC can have access to what the UNHRC has access to right now? I mean, in terms of records or maybe in terms of access to crucial officials?
So that will really depend on the engagement. So let's say that there is an ICC investigation. It really depends on sort of, I think, concluding some kind of understanding with the Office of the High Commissioner for Human Rights to determine what can be shared and what has to remain confidential. But that's for them to sort out. But it's possible, yes.
Okay, let's talk about complementarity because again, Harry Roque talks about this all the time, that the ICC should complement our national justice system. But also there's an issue of admissibility, that for the prosecution to take jurisdiction of this case, it must prove that there's an inability and unwillingness to genuinely investigate these killings. So how can you explain to us how to reconcile honoring complementarity, but also ticking off the boxes of admissibility?
That's a really good question. I think it's helpful to think of complementarity, or what the ICC's approach is to complementarity. It's not an audit of the entire justice system in the Philippines. It may be that certain parts of the Philippines justice system work really well, but that is almost beside the point. What the ICC is looking at is whether or not the Philippine government or the Philippine authorities are looking at the same cases, the same individuals for the same conduct. And if they are, and those cases are genuine insofar as they're, being effectively investigated and prosecuted, then complementarity, that would trigger complementarity and the ICC would have to step back. But in requesting this, requesting an investigation, they've made that preliminary determination that they don't think that the Philippine authorities are effectively, they're not willing or able to try the cases that they want to try. And here, remember, this is, I don't need to tell you, you know this better than anyone, that this is the government that's perpetuating these abuses. And so, if you think about it through the lens of a government that's proudly perpetrated these abuses, holding itself to account, it feels pretty unlikely.
What's the prospect for Karim Khan? What is his reputation in the international community?
So he's made it very clear. He was elected by the states because of his record and because of his commitment to the ICC's mandate. What that will mean for the ICC, I think only time will tell. Because we definitely want him to continue the outgoing prosecutors to independence and impartiality. But it's for him now to shape the next 9 years of the court's effectiveness across situations.
Prosecutor Bensouda said it herself, the ICC is at a crossroads, and in her statement, she did call for a reflection from the ICC, from the partners, from the member states. Where does the Philippines fall in that crossroads, and how will that crossroad impact the future of seeking accountability for the drug war killings?
So I think the fact that she sought this authorization and made it public on the eve of her departure says that she doesn't want the Philippines to fall between the cracks because of the gravity of the situation there. I mean, in terms of the crossroads, it's true that the ICC, the demands for justice have only grown, but unfortunately, its budget has not. And so, there's only so much that it can do with the resources that it has. And I think in her outgoing message, she's really signaling that governments need to step up. Justice isn't free, but the cost of impunity is far higher.
Right. So I'm gonna follow up with that question with my last, with that answer with my last question. There's been a lot of cynicism about how effective this ICC would be, but how do you think this procedure for the Philippines would help us improve our justice system and improve the fight for accountability a lot better?
So, I think that there is real potential, should an investigation go forward, to really spotlight, I think certainly some of the deficiencies in the cases up until now, to really puncture a hole in the impunity that has, enveloped the Philippines over the last 4 years and even before that. And so even just by signaling that, and by trying, let's say it, tries a handful of emblematic cases or a handful of, very, senior officials, that could open up the space for a robust reaction, or rather robust trials at the national level. And it also could spotlight, like I said earlier, deficiencies that, either the government of the Philippines should address, or with the help of other donor governments. But really, making that accountability picture, adding to the clarity of the accountability picture in terms of who's responsible, but also what else is needed, I think can only help the Philippines justice system moving forward.
Sorry, that wasn't my last question. The Supreme Court Justice in charge of the petition seeking to declare our drug war unconstitutional. He's going to be retiring on June 30, and the Chief Justice said they're hopeful that there could be a decision before June 30, and saying that there is, and the pretrial chamber has not acted on the request of Prosecutor Bensuda. Would a Supreme Court decision impact the pretrial chamber's decision-making process for the investigation?
I mean, I think it's certainly relevant in their assessment, but I think it could also signal that yes, this drug war is unconstitutional, but it still doesn't address the question as to what steps has the Philippines taken to hold those responsible to account. And that's ultimately what complementarity is about, and that's what this process, both the up until when the judges make a determination on whether to open an investigation, and even once an investigation is underway, to what extent is the Philippines willing and able to hold officials responsible for these murderous policies to account?
Thank you, Pam. Very helpful for us in understanding the ICC process. That was Param-Preet Singh, the Associate Director of the International Justice Program of Human Rights Watch. This is Lian Buan, and you watch Rappler Talk.